moving quickly into our next topic, which is the in-game use of trademarks. Now, when we're talking about the in-game use of trademarks, again, if you're a gamer, I think this will in some ways be familiar to you, especially if you play sports games, car racing games, games like that are designed to be at least somewhat closer to events in the real world. Certainly a sporting game. I love to play FIFA soccer. I play with my son, and I play online sometimes. And obviously, FIFA itself is a trademark, and you have the Adidas soccer ball, or the logos, the advertising billboards on the stadium, all those sorts of things. Now, with a game like that, or an auto racing game, I used to play a game called Paradise City, which I really liked. You're racing a car, through city, you're crashing through barriers, you're doing jumps. There would actually be billboards on the street with real advertisements on them. Now, how does all that work? Well, those sponsors generally are happy to have their stuff placed in the game, and in fact, there's a whole industry of product placement in video games, just like there is a whole industry of product placement in the movies. So that's one thing that's generally going to be all authorized and dealt with through commercial contracts. What we're talking about here is games that are in some way using a real or somewhat stylized or modified trademark in the context of a storyline without it being a product placement and without having permission to do so. Now, I think general rule, right, if you're representing clients that are working on video games or some kind of interactive game, I think fair advice to give them, don't use a brand name, don't have a brand name appear in the scene, don't use a brand name unless you have permission to do so, unless it's a product placement or you otherwise have permission to do so, because it's likely to lead to a dispute. But as this case we're going to look at now, Milspec Monkey v. Activision, illustrates, and as some of the other cases talked about in this case illustrate, it may not be trademark infringement, and it's going to relate to how the brand is used in the story. So Milspec Monkey opens up a whole world that I didn't really know about until I read this case. Now, I knew about the Call of Duty games. My boys love to play the Call of Duty games, much to my chagrin. And these are somewhat realistic games involving soldiers and a variety of scenarios fighting each other. What I didn't know about, and I knew within these games you can, as you advance, you can get special patches that go on your character's uniform for certain achievements. And I've got on the screen here a screenshot showing the initial patches you can get in the Call of Duty Ghosts game that was at issue in this case. What I didn't realize is this is actually a part of sort of military and paramilitary culture, that not just your unit patch, but sort of other patches for morale and other events like that are available, and that there are retailers that are selling these kind of things, and that they become popular kind of in their own right for a variety of purposes. So Milspec Monkey is one of those retailers. Here is what apparently is a relatively famous patch called the Angry Monkey, and this is that patch from the Milspec site. Here is the Angry Monkey as it appears in the Call of Duty Ghosts game. I'm going to pause for just a moment here and show you a brief clip of where those patches are in the game. You'll see how they appear and how briefly they appear, but where they are in the game. So I'm going to show you that for just a moment, and then we'll come back.
Now it takes you here. You can go to gender, headgear, uniform. Patches and background are where they are. So patches, I'm just going to go ahead and start here. Show you guys all the patches. Now I'm not going to read to you guys what all of them do. I will scroll over every single one of them like this so you guys can see. All these ones are standard issues, as you can see right here. So these are all standard issue here. Now I'm going to go to the next one and just scroll over so you can kind of read them like this. And I'll assume you guys are going to be reading these as I scroll through them, and you can pause it at any given time.
Okay, so what does the Northern District of California, again, as not surprising, an important district court for disputes involving video games, what does this court say? Well, first of all, Ghosts as a video game, Call of Duty Ghosts, is entitled to First Amendment protection. Within a setting in which there's a work that's entitled to First Amendment protection, the trademark owner can't control public discourse about the mark if the mark is being used for something more than a source identifying function. So, here's an example. I'm doing this video with you in this class. I'm holding up here a bottle of Poland Spring water. Poland Spring is a trademark, a brand name for this water. Now, this video is entitled to First Amendment protection. It is not a trademark infringement for me to be using this in this way to make this point in this academic setting. There is a doctrine of trademark fair use. That's effectively what's going on in this Milspec monkey case. Now, if I were to say, do a commercial for Poland Spring, and maybe just change the name a little bit and call it Newark Spring, right? And do a commercial. Well, that's a commercial. I'm trying to sell something. That's a source identifying function. That's the kind of distinction you want to think about. So the Milspec court says applies a test from the Second Circuit, the Rogers test, and says, well, if you're not using it for a trademark, for a source identifying function, and it's in the context of First Amendment speech, it will not violate the Federal Lanham Act, which is the federal statute involving trademarks, unless it has no artistic relevance, or it has some artistic relevance, but it will explicitly mislead. And here the court says there's no way that's happening. Nobody thinks, or the court presumes that nobody's going to think that Milspec is sponsoring Call of Duty, that Call of Duty is selling Milspec stuff or selling competing stuff. It's a patch used in the game. Now, I think you can see the logic of that. Even there, as I say that, right, no one will think Milspec is sponsoring that game. I don't know. Maybe not. But nevertheless, here's just one holding from one court, one trial court on this issue. It's an issue you want to be aware of when you're thinking about trademarks in video games.